Welcome back, students, after the short break. So, this is the final and concluding part of that session, session two. In this session, students, we are going to discuss the elements of the crime and war crimes, and thereafter other sources and other principles we are going to discuss in this part. So I'm going to share with you, students, the list of topics and slide with you regarding the this session. The students, uh, the elements of the war crimes. As earlier discussion, which has shown that the law of the war crimes has developed to criminalize a number of prohibited acts under international humanitarian law. However, it is important to note that commission of the underlying acts alone will not suffice to constitute a war crime. That is, in order to establish that a person is guilty of war crime, it is necessary to satisfy the tribunal or court that certain elements are met. In this regard, we shall proceed to distinguish between the general common requirements, which is the element which must be satisfied in order to turn a specific offense into a war crime, and the physical and mental. The physical, which is actus rea, and mental, that is the mens rea, elements of the specific or so-called underlying offense. So second part, that is the general part of the crime, which you have already, I think, you must acquainted with that. The general part of the crime. We will not discuss the general part. So what are the elements of the crime? That is the general part of the crime. But in this discussion, we emphasize on the general and common requirement, which element which must be satisfied in order to turn a specific offense into a war crime. So generally, determining the elements of the war crime requires scrutiny of the relevant statute, that is the ISTY, ISTR, and ICC, and as well as a reference to the primary source of the crime in international humanitarian law, that is the Geneva Convention of 1949. In respect of the approach taken in the ISCC, it is important also to refer to the ICC elements of the crimes, a document that assists the court in defining and applying the crime under its jurisdiction. So this document, this statute, which is reflective of the primary rules of the international humanitarian law, sets out the requisite mental and physical element for each of the acts, which listed in Article 8 of the Article 8 of the Rome Statute. For instance, grave breaches such as willful killing of the protected persons under the Geneva Conventions is a war crime. Accordingly, it is necessary to refer to the relevant provisions of the applicable Geneva Convention in order to identify the context in which a grave breach applies in humanitarian armed conflicts, and what types of the acts it includes, as well as to whom or what objects it must be committed against, that is the protected persons and objects. So in this regard, students, it comes to clear that to be found guilty of this particular war crime, it must be present that the crime was committed against protected persons as defined under the Geneva Convention and in the context of the international armed conflict. The ISTY and ISTR have defined through their case law the element of the crimes falling within their respective jurisdiction. The element of the crime adopted by the ICC now exhaustively sets out the elements of the all crimes within the ICC statute. This section will therefore first set out the general requirements that are common to war crimes, such as the existence of the armed conflict, and the nexus between the crimes and the armed conflict. Then Act set out the ICC elements pertaining to the specific underlying offences. So the what is the general or common requirements which nexus between the crime and armed conflict. So students, what is the nexus between the crime and armed conflict? The essential element for any war crimes is the connection between the criminal act and the armed conflict, whether it be an international or international conflict. Genocide and crimes against humanity are the distinct form from war crimes in that they do not need to be committed in times of the armed conflicts. This requirement is reflective of the approaches taken by both the ISTY and ISTR tribunals as well as ICC statute. Accordingly, the ISTY held in the Tadic case that for a crime to fall within the tribunal jurisdiction, a sufficient nexus must be established between the alleged offense and the armed conflict which give rise to the applicability of the international humanitarian law. So, in order to uh, in order to in order to fall within the tribunal jurisdiction, the principles which entails two requirements. Number one, there's an armed conflict and there's a sufficient connection between the crime and the conflict. So the what is the requirement of the armed conflict? Uh, the ISTY appeals chamber in the Tadic decision on the jurisdiction defined the armed conflict. I'm going to read out the principles set out in that decision, that is the Tadic decision. Whenever there's a resort to armed force between the states or protected armed violence between the governmental authorities and armed groups or between armed groups within a state, international humanitarian law will therefore apply from the start of an armed conflict and will extend beyond the cessation of the hostilities until a general conclusion of the peace or in the case of the internal conflicts. Peaceful settlement is achieved. Until that moment, international humanitarian law continues to apply in the whole territory of the warring states, or in the case of internal conflicts, the whole territory under the control of a party, whether or not actual combat takes place there. So, in case of the internal armed conflict, it is necessary to establish that the conflicts fall within the definition of an armed conflict, as opposed to the simple riot, unorganized and short-lived insurgencies, intersections, and terrorist activities, or other situation of the internal disturbance which are not subject to the international humanitarian law. Accordingly, the issue will generally be determined based on the number one, the intensity of the conflict, number two, the level of military organization of the parties, crimes committed anywhere in the territory under the control of party to a conflict until a peaceful settlement of the conflict is achieved fall within the jurisdiction of the tribunal. So, in this light, the Article 8 of the statute, ICC statute, which adopts a test similar to the test formulated in the Tadic jurisdiction decision, it defines an internal armed conflict as the armed conflict that takes place in the territory of the state when there's a protected armed conflict between the governmental authorities and organized groups, or between such groups. In Article 8 2D of the ICC statute clarifies that the ICC statute does not apply to the armed conflict not of an international character and thus does not apply to situation of internal disturbances and tensions such as riots, isolated and sporadic acts of the violence or other acts of the similar nature. Additional factors such as the involvement of the government forces on one side or exercise of the territorial control by the rebel forces are not indispensable for the determination of an armed conflict. So, therefore, the nexus with the armed conflict, the ISTY trial chamber in Tadic stated that The existence of an armed conflict or occupation and the applicability of the international humanitarian law to the territory is not sufficient to create international jurisdiction over each and every serious crimes committed in the territory of the former Yugoslavia. For a crime to fall within the jurisdiction of the International Tribunal, a sufficient nexus must be established between the alleged offenses and the armed conflict, which gives rise to the applicability of the international humanitarian law. This criterion is meant to exclude, for example, domestic crimes. So these are the students' nexus or elements which are required to establish the nature of the crime which constitute the offense of the armed conflicts, armed conflicts internationally or non-internationally. So the Yugoslavia Tribunal and Article 8 of the ICC Statute is very much clear regarding the elements of the armed conflicts and war crimes. So thereafter, students, the next topic is that the grave breach of the Geneva Convention. Grave breaches of the Geneva Convention, as earlier we have discussed, that the Article 8 2A of the ICC statute sets out the specific acts which, along with the requisite, sorry, ICC statute sets out the specific acts which, along with the requisite elements relating to the war crimes generally described earlier, must be established to have been committed against the persons or property protected under the Geneva Convention. This uh, section sets out the specific acts relating to the each crime and therefore does not reproduce the common elements relating to the war crimes under the Geneva Convention. That is that they be committed against the protected persons or property within the context of the international armed conflicts. So the grave breaches of the Geneva Conventions are: number one, war crimes of the willful killings, means any armed conflict occurred in order to willful killing of the any population. And number two, the war crimes of the torture, and during armed conflict there is a torture occurred, that is the also one of the uh, war crime. And number three, that is the war crime of inhuman treatment towards the civilians and surrendered armed forces. And number four, war crimes of the biological experiments. The relevant elements of the war crimes of the biological experiment provided in Article 2A, Clause 2.3 of the ICC Statute are that the perpetrator subjected one or more persons to a particular biological experiment. The experiment seriously endangered the physical or mental health or integrity of the such person or persons. And number six, war crime of the willfully causing great suffering. The relevant element of the war crime of willful causing great physical or mental pain or suffering provided in Article 8 2A 3 of the ICC statute is that the perpetrator caused great physical or mental pain or suffering to or serious injury to the body or health of the one or more persons. Number seven, war crimes of the destruction and appropriation of the property. And no one is allowed to destruct and appropriate the property of the other nation's state during the armed conflict. And number eight, war crime of the compelling service in hostile forces. So the relevant element of the war crime of compelling services in hostile forces is provided in Article 8 to A5 of the Statute is that the perpetrators coerced one or more persons by acts or threats to take part in the military operations against that person's own country or forces. Further, war crimes of denying a fair trial. During war crimes and armed conflicts, everyone has right to be tried fairly, and no one denied by the fair trial. Further, war crime of the unlawful deportation and transfer. The relevant element of the war crime of the unlawful deportation and transfer provided in Article 8 to A7 of the ICC statutes that perpetrators deported or transferred one or more persons to another state or to the another location is not allowed. It is unlawful and is the violation of the Geneva Convention or in the Article 8 of the ICC statute. War crime of the unlawful confinement. No one can be detained unlawfully, and unlawful confinement is a violation of the Article 8 of the ICC statute. And war crime of taking hostages. The 11th element of the war crime of taking hostages provided in Article 8 of the ICC statutes are that perpetrators seize, detained, or otherwise held hostages one or more persons. The perpetrator threatened to kill, injure, or continue to detain such person or person. So these are the uh, students' grave breaches of the Geneva Conventions, which are the violations of the Geneva Convention. And as per the Article 8 of the ICC statute, these are the war crimes. And other students, the other violations in international armed conflicts in Article 8 2b of the ICC statute provide a further list of the war crimes in international armed conflict. The offense listed in Article 8 2b required that, in addition to the listed acts, the general requisite elements relating to the war crimes of an international nature be established. That they took place in the context of the international conflict. Accordingly, the common elements relating to the war crimes in a general are not reproduce. So I'm going to mention the list of those violations or serious breaches of the international armed conflicts. That is, the war crimes of attacking civilian is not allowed. War crimes of attacking civilian objects is also not allowed, and war crimes of attacking personages or objects involved in humanitarian assistance or peacekeeping missions like Red Cross and other UN operations, those and also health assistance to the civilians, innocent persons, wounded army uh, persons. Those are also must be protected. Attack on those persons are not allowed, and war crimes of excessive incidental death, injury, or damage is also not allowed. War crime of attacking undefended places is also not allowed, and war crimes of killing or wounding a person's hostage, combat, non-combatant persons which are not taking part in the armed in the war, those are must be exempted from the attack. And war crime of improper use of flag of truce. The relevant element of the war crime of improper use of flag of truce provided in Article 8 2b, which suggests that the perpetrator used a flag of truce. The perpetrator made such use in order to feign an intention or negotiate when there was no such intention on the part of the perpetrator. The perpetrator knew or should have known for the prohibited nature of such use. The conduct resulted in death or serious personal injury. The perpetrator knew that the conduct could result in death or serious personal injury. The ICC element of the crimes notes that the term prohibited nature denotes illegally. So, next prohibition, war crimes of improper use of flag, insignia, or uniform of the hostile party. It is also not allowed. War crimes of improper use of flag, insignia, or uniform of the United Nations. Peacekeepers' uniform badges also are not used. Must not be used during the war conflict. In order to, the intention is not actually what they are perpetrating to do. war crimes of improper use of distinctive emblems of the Geneva Conventions, and war crimes of the transfer directly or indirectly by occupying power of the parts of its own civilian population into the territory it occupies, or the deportation or transfer of all or parts of the population of the occupied territory within or outside this territory, and war crimes of attacking protected objects, and the war crime of mutilation, and war crime of medical and scientific experiments, and war crime of treacherously killing or wounding, war crime of denying quarter, and war crime of destroying or seizing the enemy's property, and war crime of depriving the national of the hostile power of the rights or actions, and war crime of the compelling participation in military operations, war crime of pillaging, and war crime of the implying poison or poisoned weapons, war crime of implying prohibited gases, liquids, material, or devices, war crime of implying prohibited bullets, Indian armies use the bullets in order to attack on the eyes of the protests in the occupied Kashmir, and also Israeli forces use those bullets which cast blind the most of the innocent person in the Palestine. So these kind of weapons are prohibited, and war crime of the flying weapons, projectiles, and material of the methods of the warfare listed in the annex in the statute, war crime of outrages upon the personal dignity, and war crime of the rape, and war crime of the sexual slavery is also not allowed, war crime of the enforced prostitution, war crime of forced pregnancy, war crime of enforced sterilization, and war crime of the sexual violence, and war crime of the using protected person as a shield is also not allowed, war crime of attacking objects or persons using the distinctive emblems of the Geneva Conventions, and war crimes of the starvation is a method of the warfare, and war crime of the using, conscripting, or enlisting children, and war crime of the murder, war crime of the the war crime of the mutilation, the war crime of the cruel treatment, and war crime of the torture, war crime of the outrages upon the personal dignity, crime of the taking hostages, and war crime of the sentencing or execution without due process of law, and war crime of attacking civilians. So these are the more other crimes. As I have earlier said, there are the offenses listed 50 in number. Those are the declared as the war crime by the Article 8 of the ICC or Rome Statute. So these are the grave and serious kind of the war crimes which are actually mentioned in the Article 8 of the ICC Statute. So, students, and that was the concluding or last topic of this session, elements of the crime, which we have discussed, what conduct which and what principle which constitute the elements of the crime, which are the nature of the during which actually committed during the armed conflicts, and also we have discussed the grave and serious nature of the war crimes in a detail, and their list which I have also mentioned. But I advise you, I suggest you, you have to read out that article, the principle, the cases, in order to understand and clear the all principle regarding the offenses of the war crimes. So I hope this lecture will help you in order to understand the war crimes and nature and elements. And inshallah, in next week we will discuss the next substantive part of the this course, and next nature of the crime, because there are we have discussed there are 4 or 6 type of the crime which are internationally recognized as a universal crime of the international law. Thank you very much. See you next time.